The bulldozers were already idling at the gate when the old man walked out of his farmhouse holding nothing but a manila folder. 7 county vehicles lined the gravel shoulder of Route 9. Men in hard hats leaned against a survey truck, drinking coffee like this was any other Tuesday morning. A county attorney in a navy suit stood at the front of the group, clipboard in hand. Already rehearsing the words he'd practiced in the mirror that morning, words about eminent domain, about public necessity, about a 78-year-old farmer named Walter Merrick who was in the county's own paperwork standing in the way of progress. Walter didn't say a word. He crossed the yard slowly, his boots crunching against the frost-hardened dirt, and stopped 6 feet from the attorney. He opened the folder. He pulled out a single yellowed sheet of paper, its edges soft and furred from 6 decades, folded in a filing cabinet, and held it out. "Before your crews cross that fence line," Walter said, "somebody ought to read this." The attorney took the paper more out of habit than curiosity. His eyes moved down the page and stopped. He read it again, then a third time. The color drained slowly from his face, the way water drains from a cracked glass, and when he finally looked up, his voice had lost every ounce of the confidence it carried 30 seconds earlier. "This can't be right," he said, but it was right. Dated March 14, 1962, notarized. Recorded and never once challenged in 63 years, the deed in his hands proved something the county had never bothered to check. The only road that led to the 80 acres they wanted to turn into a 2,000-bed maximum security prison didn't belong to the county at all. It belonged to Walter Merrick. And without that road, the county's entire billion-dollar prison project was about to become a very expensive parking lot in the middle of nowhere. This is the story of how one overlooked piece of paper, tucked away by a grandfather nobody thought to ask about, brought a county government to its knees, and how an old farmer's useless back land turned out to hold the most valuable thing in the entire county. To understand how any of this happened, you have to go back to where it started, not with lawyers and bulldozers but with dirt. Walter Merrick's family had farmed the same stretch of land in the fictional rural county of Ashford, tucked into the rolling hill country of the American Midwest, for 3 generations. The front 200 acres were good land, flat, fertile, the kind of soil that grew corn tall enough to hide a truck. That was the land everyone knew about. That was the land people saw from the county highway when they drove past the old Merrick farmhouse with its faded red barn and its crooked mailbox. But behind the farmhouse, past the tree line, past the creek that flooded every spring and dried to a trickle every August, sat another 80 acres that nobody paid much attention to. It was rocky. It sat low, prone to flooding in a different way than the creek bottom, a kind of stubborn, swampy dampness that made it useless for row crops. Walter's father used to graze a few head of cattle back there in the driest months, and that was about the extent of its usefulness. For decades, most people in Ashford County didn't even know the back 80 existed. It wasn't on anybody's list of good land, bad land, or land worth arguing over. It was, by every practical measure, worthless. Which is exactly why, in 1961, Walter's grandfather, a quiet, meticulous man named Elias Merrick, was able to buy it for almost nothing from a neighboring landowner who wanted to be rid of it. Elias wasn't buying it because he had big plans for the 80 acres itself. He was buying it, according to family stories passed down over kitchen tables for 60 years, because of something else entirely: the narrow dirt track that ran through it. That track, barely wide enough for a single wagon back in Elias' day, was the only way to reach the back 80 from any public road. It cut through what had been, decades before, part of a much larger parcel, before that parcel got split up and sold off in pieces to different families. When Elias bought his 80 acres in 1961, the seller, a widow named Constance Abelman, was in a hurry to settle her late husband's estate and move to be near her daughter in another state. She sold the land and at Elias' specific request made absolutely certain that the access road, the strip of land connecting the 80 acres to the county road nearly a mile away, was explicitly included in the deed as part of the sale, not as some vague easement or unrecorded understanding, but as legally owned property. Elias recorded that deed with the county clerk's office on March 14, 1962. He filed it, paid the small recording fee, and then, as far as anyone could tell, never mentioned it to another living soul outside his immediate family. It sat in the public record for over 6 decades, technically available to anyone who cared to look and practically invisible to everyone who didn't. Why did it matter so much to Elias that he owned that road? Nobody was entirely sure. Walter always suspected his grandfather, a man who'd lived through the Depression and watched his own father lose land to a bank because of a legal technicality he never understood, simply believed that a man who controlled the road to his property controlled his own future. Access was leverage. Access was security. It didn't matter if the 80 acres themselves were good for nothing but frogs and cattails. The road that led to them was worth protecting, because someday somehow somebody might need it. Elias couldn't have known, sitting in a lawyer's office in 1962 filling out a deed with a fountain pen, that somebody would turn out to be the government of Ashford County 63 years later trying to build a prison. Fast forward to 3 years ago. Ashford County, like a lot of rural counties across the country, was facing a problem that had nothing to do with farmland at all: overcrowding. The county's existing correctional facility, built in the 1970s to house around 300 inmates, was operating at nearly triple capacity. State inspectors had cited it twice for conditions that violated basic housing standards. A federal consent decree loomed on the horizon, threatening massive fines and court-ordered releases if the county didn't act. County commissioners, most of them elected on promises of fiscal responsibility and public safety, found themselves boxed into a corner: build a new facility or face a legal and financial disaster that could bankrupt half the county budget. A new prison meant one thing above all else: land. A lot of it. State guidelines for a modern correctional facility of the size Ashford County needed called for a minimum of 60 contiguous acres, ideally isolated from residential neighborhoods, with room for security perimeters, staff parking, recreation yards, and future expansion. It needed to be far enough from town to avoid public outcry about a prison in someone's backyard, but close enough to existing infrastructure, power lines, water, and crucially, roads to make construction and operation feasible without astronomical costs. The county hired a site selection firm to survey available land across the region. They looked at a dozen parcels. Most were either too small, too expensive, or too entangled in family disputes and existing leases to acquire quickly. Then someone on the site selection team pulled up an aerial map and noticed a patch of low, undeveloped land tucked behind an old farm on Route 9, flat enough in sections, mostly unused, seemingly disconnected from any nearby development. Walter Merrick's back 80 acres. On paper, it looked perfect. County records outdated, incomplete county records, as it would later turn out, showed the parcel as agricultural land with minimal assessed value. The narrow track running through it toward the county road was marked on old county maps in a way that made it look, to anyone glancing quickly, like it might already be a public right-of-way, one of countless small dirt roads that counties sometimes maintain informally without ever formally deeding. Nobody on the site selection team pulled the original 1962 deed. Nobody cross-referenced the recorder's office archive against the modern GIS mapping system, which had been built decades later using aerial surveys and assumptions rather than a careful review of every individual property transaction. It was an understandable mistake, the kind of clerical oversight that happens in county offices every day, except this particular oversight was about to cost the county millions of dollars and years of delay. The county's plan moved forward. An appraiser assessed the 80 acres, low agricultural value. Minimal improvements, no residential structures. And the county commission authorized an offer to purchase the land from Walter Merrick for a price that was by any honest measure an insult. Less than half of what comparable land was fetching elsewhere in the county. Based entirely on the assumption that this particular parcel was worth next to nothing. The first time anyone from the county contacted Walter Merrick about the back 80, it wasn't a bulldozer crew. It was a letter. It arrived on a gray October afternoon, tucked between a seed catalog and a property tax statement. Walter read it standing at his kitchen counter, the same counter his grandfather had eaten breakfast at every morning for 40 years. The letter was polite, formal, and utterly indifferent to the fact that it was proposing to take land that had been in his family for 3 generations. The county, the letter explained, was pursuing acquisition of an 80-acre parcel identified as ideal for a new regional correctional facility, a project described as vital to public safety and essential county infrastructure. An initial appraisal had been conducted. An offer of $92,000 for the full 80 acres was being extended, described in the letter as fair market value based on current agricultural assessment. Walter had 30 days to respond. If a voluntary agreement could not be reached, the letter noted, almost as an afterthought, buried in the second-to-last paragraph, the county reserved the right to pursue acquisition through eminent domain proceedings, as authorized under state law for projects serving a demonstrated public purpose. Walter read the letter twice. Then he set it down, poured himself a cup of coffee that had gone lukewarm, and sat at the kitchen table for a long time without moving. He wasn't naive about eminent domain. He'd watched it happen to a neighbor 15 years earlier when the state widened the highway. Watched a family lose 40 acres of good bottomland for a fraction of what it was worth because the government's appraiser and the family's appraiser had wildly different ideas about fair, and only one of them had the power to enforce his opinion. Walter knew that fighting the county head-on, acre for acre, dollar for dollar, was a losing game for a man his age with a modest retirement account and no army of lawyers. But something about the letter nagged at him. Not the money, though $92,000 for 80 acres, even bad land, felt low. It was the description of the road. The letter mentioned, almost in passing, that the existing access route would be improved and expanded as part of the project to accommodate construction and later staff and visitor traffic. It talked about the road as if it were simply there, a given, a piece of infrastructure that came bundled with the land like a public utility. Walter had grown up hearing his grandfather talk about the road, in a tone that was different from how he talked about everything else on the farm. Elias Merrick rarely spoke about business matters with any weight of ceremony, but he'd told Walter more than once, usually while walking the fence line as a boy trailed behind him, "That road's not the county's, that road's ours. Don't you forget it, and don't you ever let anybody tell you different." At the time, young Walter hadn't thought much of it. It seemed like the kind of stubborn, old man pronouncement that farmers made about all sorts of things, pride of ownership over a strip of dirt nobody else cared about. But sitting at his kitchen table with the county's letter in front of him, decades later, those words came back with startling clarity. The next morning, instead of calling a lawyer, Walter drove into town and walked into the Ashford County Recorder's office. The Ashford County Recorder's office occupied the ground floor of the county courthouse, a squat brick building that had been renovated twice since the 1960s, but still smelled faintly of old paper and radiator dust. The clerk on duty, a young woman named Denise who'd worked there less than 2 years, wasn't quite sure how to help Walter when he explained what he was looking for. A deed, possibly from the early 1960s, related to a parcel his grandfather had purchased. "Do you have a parcel number?" she asked. Walter didn't. What he had was a name, Elias Merrick, and an approximate year, and a story his grandfather told him decades ago. Denise disappeared into the back for the better part of an hour before returning with a thick, dust-covered index book, and eventually, a microfilm reel that hadn't been touched in years. Older records, especially anything predating the 1980s digitization efforts, existed only on microfilm, or, in some cases, in physical ledgers stored in a climate-controlled basement archive that required a supervisor's authorization to access. It took most of a day. Walter sat in a small reading room with a microfilm viewer that hummed and flickered, scrolling through page after page of property transactions from the early 1960s. Sales, transfers, mortgages, releases, a slow-motion archive of a county changing hands, parcel by parcel over decades. And then, close to closing time, he found it. Book 47, page 213. A warranty deed dated March 14, 1962, transferring property from Constance Abelman to Elias J. Merrick. The legal description written in the dense formal language of mid-century property law. Described not just the 80-acre parcel behind what would become the Merrick farm, but also, in a separate paragraph clearly delineated, a strip of land 60 feet wide, running in a described path from the eastern boundary of the parcel to its intersection with the county road. Explicitly conveyed as part of the sale in fee simple without reservation or easement to any third party including Abelman herself or any successor. In plain English, Elias hadn't just bought the 80 acres. He'd bought the road leading to it outright, and the deed said so in language that left no room for interpretation. Walter requested a certified copy on the spot. Denise, sensing something significant was happening even if she couldn't quite articulate what, processed the request personally, and had the copy ready within the hour, complete with the county seal and a certification stamp confirming it as an authentic, currently valid record. Walter drove home with the copy on the passenger seat of his truck, glancing at it at every stoplight as if it might disappear if he looked away too long. That night he called his nephew, a paralegal working in the state capitol, and read him the legal description over the phone, word for word. There was a long pause on the other end of the line. "Uncle Walter," his nephew finally said, "if this deed is what it sounds like, and nobody's touched that road's ownership in 63 years, the county doesn't just need to buy your 80 acres. They need to buy the road too. And if you don't want to sell them the road." He didn't need to finish the sentence. Walter already understood. Walter's nephew put him in touch with a property attorney named Rebecca Solano, a sharp, methodical lawyer with a reputation in the region for handling exactly this kind of dispute. Cases where old records collided with new government projects, where the fine print of history turned out to matter more than anyone expected. Rebecca spent 2 weeks doing what the county's own site selection team should have done months earlier. A full title search, cross-referencing every deed, easement, and transfer connected to both the 80-acre parcel and the access road, going back as far as records existed. What she found confirmed everything the 1962 deed suggested and added a crucial additional layer. The county's modern GIS mapping system, the digital maps used by planners and assessors, had inherited an error from an aerial survey conducted in the late 1980s. That survey, done to modernize the county's outdated paper records, had misclassified the access road as part of the general road network, likely because it appeared on older county maps as a traveled way, a term used historically for any regularly used dirt track, regardless of legal ownership. Over the following decades, that classification error simply propagated forward, copied from one system update to the next, never questioned, never verified against the actual chain of title. The county had been treating the road as public property for nearly 40 years, based on nothing more than a decades-old mapping mistake. In reality, no such transfer had ever occurred. Elias Merrick's ownership, established in 1962, had passed cleanly to his son, and then to Walter through standard inheritance and estate proceedings, each transfer properly recorded, each one confirming the same boundaries, the same legal description, the same 60-foot wide strip of road. Walter Merrick didn't just own 80 acres of swampy, low-value farmland. He owned the only legal, recorded access point to that land, a fact the county's own multi-million-dollar prison project depended on entirely, and a fact the county had somehow never bothered to confirm. Rebecca laid out Walter's options carefully. He could simply refuse to sell the road, which would leave the county's chosen site legally landlocked, no lawful way to bring in construction equipment, utility lines, or eventually staff and visitor traffic. Without either building an entirely new access route from a different direction, expensive and dependent on acquiring land from other property owners who might prove just as difficult, or negotiating directly with Walter on terms that reflected the road's true value, not its assessed value as agricultural land. Or, Rebecca suggested, there was a second option: negotiate from a position of overwhelming strength. Walter didn't have to refuse to sell. He simply had to make clear that he understood exactly what he held, and that the days of a $92,000 lowball offer for land the county quietly needed far more than they were letting on were over. Walter chose to fight not out of greed, he'd later tell a local reporter, but out of principle. "My grandfather bought that road because he believed a man should never be at the mercy of somebody else deciding whether he gets to use his own property," Walter said. "I wasn't about to let the county walk over 60 years of him being right." Despite the letter's 30-day deadline, and despite Rebecca formally notifying the county's legal department of the title discrepancy in writing, the county's engineering department proceeded as though nothing had changed, whether through bureaucratic momentum, a breakdown in internal communication, or simple disbelief that a retired farmer's paperwork could derail a project already months into planning and partially funded through a state infrastructure grant. County crews were dispatched to begin preliminary survey work on the access road, the same road Walter now had a certified deed proving he owned outright. That was the morning the bulldozers idled at Walter's gate, the morning captured in the opening of this story. The county attorney present that day, a man named Gregory Havorson, had been sent specifically to smooth over what his office still believed was a minor procedural dispute, a farmer unhappy about the price, nothing more. He was not prepared for a deed. Havorson's reaction, once he understood what he was holding, was immediate and unambiguous. He ordered the crews to stand down on the spot and called the survey off entirely, unwilling to authorize a single shovel of dirt moved on land whose ownership was now in serious legal dispute. Photographs taken by a neighbor that morning, later published alongside the story that made Walter Merrick briefly a minor local celebrity, show the survey truck still parked at the fence line, its crew standing idle while Havorson stood with the deed in his hands. Phone pressed to his ear, already relaying the situation back to the county commission. Word spread through Ashford County within days. Local news picked up the story: farmer's old deed stalls county prison project. A regional paper ran a longer feature a week later, complete with a photo of Walter standing at the edge of his back 80, the yellowed 1962 deed framed in his hands like a trophy. Public reaction split sharply. Some county residents, frustrated by years of overcrowding headlines and worried about the consent decree looming over local finances, viewed Walter as an obstacle standing between the county and a necessary, if unpleasant, solution. Others, particularly longtime residents, who remembered how the highway widening years earlier had steamrolled another farming family, saw Walter as something closer to a folk hero. An ordinary man who'd outmaneuvered the government using nothing but patience, memory, and a piece of paper the county itself had failed to read. Faced with a legally landlocked prison site and a public relations situation growing more complicated by the week, the county commission convened an emergency closed session. 3 options were presented by county staff. The first was to pursue eminent domain not just over the 80 acres, but over the road itself, forcing Walter to sell at a court-determined, just compensation value. Rebecca had anticipated this move and was ready with a counterargument that gave the commission serious pause. Eminent domain requires a demonstrated public purpose, and while a prison arguably qualified, courts in the state had shown increasing skepticism toward eminent domain actions that appeared to follow rather than precede. A landowner asserting a legitimate property right the government had previously ignored. Worse, because the road itself had never been assessed at anything close to its functional value, it had been buried inside the low agricultural value appraisal of the whole 80 acres. The county risked a protracted valuation battle in court that could easily stretch on for years, delaying the prison project far longer than simply negotiating with Walter directly. The second option was to abandon the site entirely and start the search over, a proposition that horrified commissioners already facing pressure from the state to resolve the overcrowding crisis quickly. Starting over meant months, possibly years, of new site selection, new appraisals, and new environmental review, all while the existing facility remained under federal scrutiny. The third option, quietly floated by one commissioner who'd grown increasingly uneasy about the whole affair, was simply this: call Walter Merrick. Apologize for the lowball offer and the survey crew showing up unannounced and negotiate an actual fair deal. One that reflected not the assessed agricultural value of 80 swampy acres, but the true, irreplaceable value of the only legal access route to a project the county desperately needed to build. After a tense debate that reportedly grew heated enough that one commissioner walked out temporarily, the third option won out, not out of goodwill, but out of pragmatism. The county simply had no faster, cheaper path forward. The renegotiation took place over 6 weeks, conducted almost entirely between Rebecca Solano and the county's outside legal counsel, with occasional direct meetings between Walter and the county commissioners themselves. Walter, for his part, never asked for anything unreasonable. He didn't try to block the prison out of spite, and he didn't demand an outrageous windfall simply because he now held the upper hand. What he asked for was straightforward: fair market value for the 80 acres, calculated honestly rather than dismissively, a separate, appropriately valued payment for the road itself, reflecting its function as essential infrastructure rather than incidental farmland, a guarantee that the existing farmhouse and front 200 acres, which the county had never targeted, but which Walter worried might eventually be eyed for expansion, would be permanently excluded from any future county land acquisition related to the facility, and a formal written apology entered into the public record, acknowledging that the initial appraisal and survey attempt had been conducted without proper verification of the property's legal status. The final agreement, signed roughly 4 months after that first letter arrived in Walter's mailbox, set the total compensation at just over $740,000 for the 80 acres and the access road combined, nearly 8 times the county's original offer. It included the requested protections for the remaining farmland, and it included, buried in an addendum most reporters barely mentioned, but that mattered enormously to Walter personally, a formal acknowledgement from the county commission that the original valuation had failed to account for material facts regarding the property's legal status. Construction on the new Ashford County Correctional Facility began the following spring on the same 80 acres using the same access road, now properly and permanently deeded to the county as part of the settlement, with a formal easement recorded to prevent any future confusion of the kind that had started the whole saga. Walter Merrick used a portion of the settlement to pay off the last of the farm's mortgage, something his father and grandfather had both hoped to do in their own lifetimes but never quite managed. He set aside a portion for his grandchildren's education. And in a detail that made the local paper's follow-up story a little more poignant than the first, he had the original 1962 deed professionally preserved and framed and hung it in the farmhouse hallway. Not far from a black and white photograph of Elias Merrick, standing at the edge of the same back 80 acres decades before anyone knew what that quiet, stubborn purchase would one day be worth. When a reporter asked Walter, months after the settlement, why he thought his grandfather had gone out of his way in 1962 to make sure that scrap of road was legally his, Walter thought about it for a long moment before answering. "I don't think he knew this would happen," Walter said. "I don't think anybody could have known that. I think he just believed that if you own the way in, nobody can ever force you out. He wasn't planning for a prison. He was planning for the fact that somebody someday might try to take something from this family. And he wanted to make sure that when they came, they'd have to knock on the door and ask instead of just walking in." The story of Walter Merrick's road spread well beyond Ashford County. Property law professors at a nearby state university began using an anonymized version of the case in their courses, as a real-world illustration of why title searches and chain-of-custody verification matter, not just for buyers and sellers, but for governments wielding the enormous power of eminent domain. County recorders' offices in at least 2 neighboring counties reportedly launched internal audits of their own GIS mapping systems after the story broke, worried that similar decades-old errors might be lurking in their own digital records, waiting for the wrong government project to stumble across them. And somewhere in a filing cabinet drawer that no longer needed to be opened, the original 1962 deeds certified copy sat quietly with the rest of Walter Merrick's important papers, proof that sometimes the most powerful thing a person can own isn't the land everyone can see. It's the road nobody thought to check.